Okay, thank you very much. I do apologize for the sound quality. I believe we have it fixed now. So what I would like to do, first part of the presentation, is just give a little bit of background on the Legal Profession Act, where we've come from. So a brief history of the current act. The Law Society of the Northwest Territories was established, we know it was around in 1898. It was a full-fledged regulator, and we were self-governing and independent of government. In 1905, the provinces of Alberta and Saskatchewan were carved out from what was then the Northwest Territory. The Law Society appears to have morphed into the Law Societies of Alberta and Saskatchewan. From this period, the history is not clear of what happened between 1905 and 1938. In 1938, the Legal Profession Ordinance of 1898 was repealed, and the profession lost its self-regulating status and was administered by the commissioner in Ottawa. The Law Society at that point ceased to exist. In 1976, the Law Society was created, and the ordinance at that time was based on the Alberta Act, and self-regulating status was restored. In 1988, or around 1988, the ordinance was carried over to become the Legal Profession Act, and the Legal Profession Act came into being. Since that time, there have been some amendments, but the current act dates back from 1976. The biggest addition or biggest amendment to the act since then was the addition of the discipline provisions. And certainly one of the reasons why went through this process was to also update the discipline provisions. I want to talk a little bit about the review committee. So as I indicated, the Legal Profession Act is around 44 years old. The provisions date back at least 44 years and date back much further. We recognize that the language used was old, somewhat out of date, and the act was not reflective of modern usage and modern practice. We recognized that we needed to have a Legal Profession Act that was reflective of the Northwest Territories. The Northwest Territories is unique in Canada, and we wanted to attempt to have an act that sets that out. We also followed up on some of the strategic planning exercises that had been going on. And we recognize that in order for the Law Society to maintain the confidence of the public and regulate in the public interest, we needed to emphasize values that are very important to us in the Northwest Territories: transparency, diversity, and inclusion. And we needed to have a Law Society and an act that would be reflective and supportive of the population of the Northwest Territories. Certainly, top of our minds at that time was the importance of reconciliation, the recommendations of the Truth and Reconciliation Committee. We wanted to ensure that the Law Society was more representative of the people that we serve. We also considered the importance of access to justice, and we wanted to make our act one of the best in the country. So the committee was established in August 2018. As the past president, I already had done some work and laid the groundwork for this process. I was designated by the executive to chair the committee and steer the project through to completion. The terms of reference are before you. The terms of reference provided a roadmap for the report. We refer to this as a discussion paper on changes to the Legal Profession Act. Our terms of reference talk about consultation that we would undergo We sent out emails to our membership asking, first of all, if there were any areas of concern in the current act, give us some input. Those were reviewed, and some of those comments became part of the discussion paper. We also sent the discussion paper out to our membership, and those comments were reviewed. The final report was also reviewed at our annual general meeting, and there were some comments from that. We also consulted widely in other jurisdictions. We did a jurisdictional scan. At the time, there was a lot of work being done by other jurisdictions in terms of updating their governing acts, and we wanted to use some of their examples. So the discussion paper was completed in September 2019. It was circulated to the bar. There were a number of comments received by members of our law society, and a supplementary report was presented to the executive in early 2020, and it was approved by the executive. There were a number of recommendations made in the discussion paper. We're not going to speak to all of them. We've highlighted a number of them here. And we're going to speak to some of the main themes. It's by no means a get into the weeds kind of presentation. It is rather high level. We wanted to give you a sense of what was on the mind of the committee at the time and what went into the discussion paper, and ultimately what is reflected in the draft bill. I want to refer briefly to the which our committee was influenced by the work that was going on by the governance review of the Law Society of BC. This was going on at the same time that we undertook our review of the Legal Profession Act. I just want to quote what is on the bottom of that report, because I think that's top of our minds. It says, a legal profession that is incapable of achieving outcomes that resonates with what society expects is one in which the public will eventually lose confidence. And that's very much a guiding principle. We have to remember that as lawyers, we're here to provide our services in the public interest. We are not, the Law Society is not a member benefit society. We also recognize that there are many different voices that make up our population in the Northwest Territories, and these need to be reflected in what we do as a law society. So it's very important during this process that we keep the public interest in mind. And we asked ourselves many times while we were working on the draft, on the discussion paper and moving forward, what does the population, what does the public in the Northwest Territories expect of the Law Society, the executive, and those that it regulates? Now, throughout the draft bill, we use the term registrants. Ian will address that, and the term is used to address different classes of individuals who are regulated by the Law Society. I just want to address, some may say when we wrote the discussion paper and is reflected, which is reflected in the draft bill, some may say that on many issues, the committee and the bill does not go far enough. I want to emphasize that the committee took a very pragmatic, practical view. We wanted to create a bill with language that was flexible and could adapt to changing circumstances in the next decade and possibly for another generation. So the next slide highlights a number of areas that are likely to be of interest to the bar, and we will go through those. The first is the purpose of the Law Society. you'll notice the definition that we arrived at, which really stresses the importance of professional conduct, transparency, and consensus. I think we modeled that on the Nova Scotia definition used in Nova Scotia. The important points are highlighted. Very top of the mind was the role of laypersons and the need for diversity and inclusion in our executive and reflected in the Law Society. We recognize the importance of laypersons and their role in the Law Society. We also recognize that one non-lawyer layperson on the executive, we appreciate would often feel overwhelmed speaking and sitting around the table, sharing ideas with 5 or 6 different lawyers. We recognize the need to have community members on committees. It's a good way to get people involved. We also recognize the importance of having Indigenous voices around the table. We recognize the importance of the Law Society being inclusive. And I want to underline that there's no restriction on a layperson potentially becoming president of the Law Society. So we do have in the new act, there's opportunities for lay members to be on committees, as well continuing to be a member of the Complaint Investigation Committee. We spent a lot of time as a committee talking about the practice of law, what that entails, how the practice of law should be reflected in a new act. We came to the conclusion that the definition that we had in the current act is just not broad enough. It doesn't capture all the activities that are now part of the practice of law. It might very well have been sufficient back in the 70s, but as we all know, the practice of law has changed, and we wanted to reflect that. So we wanted a broader expression of what the practice of law is. So we've tried to do that as you see here, this is the definition of the practice of law. In the new act, it's much broader. I also want to point out that the exceptions are much broader, and they reflect the current practices in the Northwest Territories. I want to underline that there is an exception for unions and Indigenous organizations. We've also tried to add room or make space for alternative service providers and leave options open for change and additional providers of legal services in the future.
Registrants is another area of interest. This is directly related to the Cayton Report. There's a problem the Cayton Report identified with many professional regulating bodies or governing bodies in that they often refer to a member of the association or governing body. And one has to inquire as to what the purpose of the society is. Is it a members organization, a members benefit organization, or is it some sort of public interest organization serving the public interest? And of course, it's the last one, the public interest regulatory body. So there is a systemic problem that's present in the current act with regard to the rules, in that a member in the current act tends to be focused on lawyers only. So there are different classes of other people. So for example, students of law or law students tend to be treated separately. And then there's other classes of limited legal service providers, such as the Canadian Legal Advisor, the Restricted Appearance Certificate Holder, or even paralegals if they were to be considered as well. So there are problems with this term member. In the discussion paper, you'll see that we talked about member being changed so that it meant more of an umbrella term. And we've actually gone with registrant instead to get away from this idea of a member benefit society. Other jurisdictions tend to use registrant or licensee. We use the term registrant because one has to register. So if you register, you're a registrant. You can see that in the definitions in section in part 1 and also in part 3 of the bill. And we also have this concept of limited legal service provider. So this diagram here is actually a conceptualization of the different terms. And you can see that we have the Law Society of Northwest Territories and the number of personalities identified in this diagram. It's meant to be sort of like a Venn diagram. I think we actually call those unit diagrams. And you can see the different classes of registrant present, active and inactive registrants, lawyers, students at law, law students. And we have this concept of limited legal service providers, which might include paralegals, but that depends on the rules. The Attorney General could be an active registrant in certain cases. And then we have some other people that are floating about, such as the lay members, the executive director, and so forth. So in this diagram, where does a Canadian legal advisor fall? A Canadian legal advisor, if you recall, there are two types of person that could be. That could be a member of the Bar of Quebec, or it could be a member of the Chambre des Notaires. Canadian legal advisors who are in fact members of the Bar can actually apply to be a lawyer. But the ones who are members of the Chambre des Notaires, they aren't qualified to be a lawyer. So they would be certainly in the class of limited legal service provider. And obviously the rules have to be made up to deal with this. Similarly with the restricted appearance certificate holder, they are not a lawyer because they're not registered as a lawyer in the Northwest Territories. What they are is a limited legal service provider. So they can actually provide limited legal services in respect of the case for which they're registered. And then court workers and paralegals would fit in if they were so prescribed in the rules. Competency and conduct is also a major part of the bill. It's addressed in part 4. This is the process to allow for resolution of a complaint by a process other than investigation. That is always prevalent. So there are always options. One doesn't have to go directly to an investigation. There are ways out of it. In the court system, as many people are aware, this is called a diversionary system. And it's a means of applying a solution to the dispute that is more proportional, more efficient, less costly, and time consuming to all parties involved. But at the same time, it achieves an opportunity to not go straight into an adversarial situation. And I mean, an investigation is not necessary in most cases, and the complaint can be dealt with through other processes. We know of this as alternative dispute resolution. The current act is based on the hard court discipline model, so it lacks the proportionality and the efficiency. One of the approaches that was used in this design was a carrot and stick of positive and negative incentives to avoid investigation in a tribunal hearing. So this is the concept is present in section 31 of the draft bill, and you can see that there's two important here or definitions. the concept of incompetent conduct and the concept of sanctionable conduct. One is more serious than the other. This is a very simplified process flow of the stages for going through the competency and conduct process. I don't want to use the term discipline because we're getting away from that. So typically a complaint is received, then there's an initial filtering of the complaint, an assessment by the chair to determine if it's frivolous or vexatious, if there's sufficient jurisdiction to deal with the complaint, and so forth. If not, it gets dismissed. There is a process for review of that dismissal. It could also go to a process. So if it doesn't get dismissed, or the review results in it being reactivated, then there's an option for it to go through a process other than investigation. And then if there's a resolution, great. There's no publication, and that's the end of the matter. If there is no resolution, then it has to go through the investigation process. And in certain cases, some activities go straight to investigation. And there is still an option for process other than investigation. And again, in certain cases, it may end up going straight to the tribunal after the investigation. And once you get into the investigation process, the second stage of process other than investigation, the stick starts to apply. So the results of the process of investigation are actually published. Similarly with the full-scale tribunal hearing. So this is quite an innovation over the current act. The rules is another area of interest. This is quite technical. Basically, there has been some concern about whether the rules of the Law Society are in fact statutory instruments. Some are of the view that they might be, that there's uncertainty on that. We are making it clear that they are not statutory instruments. So they would be, if we continue to register them, they would be registered as non-statutory instruments. Even though right now they're registered with an R number, which suggests that they are statutory instruments, but there is some doubt about how that works under the current statutory instruments act. Anyway, the intent of section 67 is to actually resolve all of that. And there is a discussion about how Nunavut approached that issue in the discussion paper, because they encountered the same problem. The Public Printing Act will not apply, so currently rules of the Law Society are under the public printing exemption regulations. And the Law Society still has to make them available to the public. The consequences of failure to comply are quite important. And you can see that where a registrant fails to comply with the rules of the Law Society, it's not an offense under the Act or anything like that. What it is it can lead to a complaint and put you into the competency and conduct process stream we just discussed. There's also some details about the subject matter. This is basically the inventory of the subject matter that for which rules can be made. It's very general, actually. Codes and standards. So we do have a code of interest, the model code of conduct. For the I don't think it's called the model code anymore. And what we have tried to do is capture the latest work and thinking on codes and standards. So this is probably going to be a model for other professions as well. So the executive can make rules adopting a code of conduct or standard. When the code of or standard is adopted, the code or standard has the same legal effect as a rule. So that means if you breach it, it goes to the competency and conduct process. And the wording is critical there to have the same legal effect. Otherwise, the code or standard would just be quasi-legislative, not a particularly great legal effect. And then there's a standard type of provisions on the admissibility of codes and standards.
Okay, so we've reached the end of our presentation. By way of summary, we provided some background. We wanted to create a Legal Profession Act that was made in the Northwest Territories and reflective of current practice in the Northwest Territories. The review committee spent a lot of time. They consulted with the membership and with others to determine what people felt was important to have in the Act and how to regulate the legal profession in the public interest. As I indicated, we did look at the Cayton Report. One of the themes that underpins all of our work is that we are not here to benefit our members. We're here to regulate the legal profession in the public interest, and we're certainly aware of the significance of that. We went through some of the sections of the new Act that we felt were significant. We have about 20 minutes. We're prepared to take questions that you might have. And Ian will also speak to what's next in this process.
Okay, well, I'll speak to what's next in this process for now. We have a draft bill, so comments can be sent to the Law Society. If you have any comments as you digest it. And there is the email to the Law Society. If you are providing comments, please be sure to cite which provision, if you are citing a provision that you're referring to. And those comments will be considered by the Law Society and also the department. The bill will then be approved by Cabinet and introduced to the Legislative Assembly. And there will be opportunities for further input through the legislative process. There is in Section 71 coming into force provision, so the Act would not come into force until an order is issued. And as Jessica had indicated just before this presentation, that should give sufficient time for rules of the Law Society to be made in respect of the Act. So are there any questions? Does anybody have any thoughts on the draft bill or the presentation?
Other than the sound quality.
Hi guys, I've got a question. Can you hear me?
Yes.
Thanks. Thanks for the presentation. I appreciate that. Just curious if when you were drafting, you did a bit of a jurisdictional scan on whether or not other jurisdictions are permitting a layperson to be president of the Law Society. If other jurisdictions are doing that, or if we are cutting the cutting edge.
When I was drafting, we would not have done a jurisdictional scan. The jurisdictional scan would have been done when the discussion paper was being drafted. I'm not aware of that being identified in any meaningful way.
Okay, thanks.
Laura has a question.
Oh, some people were raising their hand.
Yes.
Some people were raising their hand.
Yeah.
Sorry about that.
So I just pulled up the, can you hear me?
Yes.
Yeah, I just pulled up the definition of practice and law. So I'm actually feeling a little less concerned. But I know that you stated that you were trying to make it a little bit more general and less detailed, and possibly wider. I guess my concern is that whether there was thought given to making sure it doesn't capture legal information. Legal information is a really great access to justice tool that allows you to convey, really forthright information without giving advice to someone, which allows flexibility in how much you can help them, right? So I just wanted to make sure that that had been considered before it's too much wider, as the old definition was a bit difficult.
So we've got an interesting point. We've got practice of law. I think the answer might be in subsection 4 there, 21 sub 4. So practice of law is the application of legal, so 21 sub 1, practice of law is the application of legal principles of judgment with regard to the circumstances or objectives of a person that requires the knowledge and skill of an individual trained, etc., and includes. So provision of legal information would probably be immediately discounted by what came there at the beginning of subsection 21 sub 1. To be more specific and more
Right, thanks.
practice of law.
No, that's great.
Not the practice of law.
I do have another question if no one else has a question.
Sure.
So I think in the past, there's been some difference of opinion on how it applies to students, law students, not students at law, and what really requires temporary articles. And our reading, or who I was working with at the time, was that it's quite similarly worded to how it would operate in other jurisdictions. So unless your law student who's working with you is actively giving legal advice, going to court, that kind of thing, yes, they would need temporary articles for that. But simply being a law student and working in the Northwest Territories, maybe during your summer, maybe doing research on behalf of a lawyer that does all the conveying of the advice, the opinions, would not require temporary articles. And that would be consistent with how I read it and also how other jurisdictions do it. At the time, though, we were told that simply being a law student working in the Northwest Territories requires temporary articles. So I'm wondering if that's been clarified.
I can answer that a little bit. Your question seems to merge the concepts of student at law, which is an articulate student, with the concept of a law student. So they are different. A person who is an articled student or a student at law, it's a defined term in the current act and also in the current rules. And that is actually somebody on a path to become a lawyer. In terms of a law student, that is a person who might be at law school, but they haven't been admitted into an articling program because they haven't graduated from the law school. So a law student should have fewer privileges than does a student at law. Student at law, of course, can do certain things within the confines of the rules of court and also the rules of the law society. But they are also accountable to their principal and also to the law society. And certainly in this bill, they're going to be accountable for competency conduct as well. With respect to a law student is also accountable to their principal. They would not be an articled student, but under the current bill, they would also be subject to the competency and conduct provisions of Part 4. Does that?
Okay,
address your
so
question?
yeah, I definitely understand the difference between a law student and a student at law. So what I'm talking about is kind of akin to a temporary articles, which is not a articling student. It's where they are given, privileges or abilities to give legal advice before they become a student at law on a temporary basis based on what they're actually going to do at work. Not simply because they're a law student, but because as a law student, they're also doing, legal practice. And I think that is consistent with how it's done in other jurisdictions as well as the wording, but maybe I can take this offline and submit it as a written comment.
You can also see in subsection 2, 21 sub 2, that prohibition about who may practice law refers to people who are exempt, are actually registrants. Only a registrant of the society can do that. The definition of registrant includes student at law and also law student.
I guess just my confusion is that I don't really know of any other jurisdiction that requires all law students to be registered with the Law Society. I think that's the great thing about being a law student. You still get to decide whether you actually want to join the Law Society or not. So yeah, it's just confusing to me how maybe we're approaching this in Northwest Territories. If you want to hire a student just to do your research, it's completely normal.
Okay, thank you.
There's another hand up here. Matt, you have a question?
Yes, I do. Can you hear me?
Yes.
Yeah, I've got another question on section 21 in relation to the definition of the practice of law and the prohibitions on unauthorized practice, and then the exemptions from the application of section 21. And I'm wondering whether consideration was given to a broader exemption for Indigenous legal practices, traditions, and customs, having regard to the fact that law isn't defined in the Act?
That's a really good point, and it's certainly something that we can consider further. It's a valid point, and it's an important point.
Great, thanks.
Pam?
Hi, can you hear me?
Yes.
Yeah. So I've been reviewing the new section on competency and conduct, and I have probably several comments about that, but I just had a couple questions that sort of come to mind under section 34, sub 2. You talk about when a complaint is to be dismissed and the complainant can request an internal review of the dismissal. I'm just wondering if there's been any thought as to how that internal review is, what that looks like. Who does that? What's the process there? Has there been any consideration of that?
I can, if we look at 34 sub 2, where the chair dismisses a complaint under subsection 1 and the complainant requests an internal review of the dismissal in an approved manner and form, the executive shall, within 60 days after receiving notice of the request and in accordance with the rules, carry out an internal review of the dismissal. So it seems to me that the provision leaves a fair bit to be prescribed in the rules. So there's a fair bit of discretion on the part of the executive, which is the rulemaking authority under the act. So the act does not address that in any detail. It appears to have left it to the rules, or at least the rulemaking authority.
I just have one other question as well that comes to mind. It's right near the beginning of that part, section 32, sub 3. The complainant under this part has no standing in any proceedings under this part. So I do understand that in terms of, say, an like if it went to an arbitration or tribunal. But what about sort of informal resolution? Are you saying that the complainant doesn't have any say in an informal resolution? That's kind of what that sounds like to me.
This provision is a reflection on the Diwali case, which is mentioned in the discussion paper. So it's a reflection of the common law. Whenever there is an investigation or a complaint that's looked into by the Law Society, and this is the current law as well, the complainant is not actually a party to the proceedings. The two parties to the proceeding are the subject of the complaint and the Law Society. And the theory behind that is that the Law Society is actually the public regulator, and it's them that is looking into the matter that is being brought up by the complaint. But, yep.
Yeah, so I understand that. And I guess it's under the part that says proceedings against a registrant. But, you know, if we're contemplating quite a bit of change with respect to some sort of alternative dispute resolution, you would think the complainant would be a party to that and have a say in how it is to be resolved if it's an informal process.
No, that is, we take your point and would like to do some more work on that and consider that further.
Okay. Thank you. I probably do have some other comments, but I will submit those in writing as well.
Thank you.
Are there any other questions? Laura has a question.
Yeah, I just wondered if there was any thought given to a community advocate model. So in other jurisdictions, non-lawyers are allowed to give limited legal advice if they're supervised by a lawyer. And so there are either community legal workers or advocates, and there's structures around how they can give advice, how much they can't go to court, that sort of thing. And I was just wondering, because our jurisdiction here obviously has a lot of remote communities, and yeah, they don't have lawyers in all of them. So I was wondering
Yes,
that.
it's probably covered by this concept of limited legal service provider and a class of registrant. Just how that's dealt with would be determined by the executive through the rules, rulemaking process. So bumped into that community advocate type role that you have suggested would be others, including court workers, family law advisors, paralegals, and so forth.
All right, if there are no further questions, we thank you for taking the time to be part of today's discussion. We invite you to submit by email further comments or questions or insights that use moving forward. And the email address for comments is on the slide.
Okay, thank you very much. With that, we'll end this presentation. Thank you for your time and have a good afternoon.